जय हिंद एवरीवन। आज के एडिशन में वी आर गोइंग टू टॉक अबाउट डिसेबिलिटी पेंशन एंड lifestyle related disease, how the two have interplay between each other. We have with us today Advocate Harshvardhan, who is practicing in the principal bench of the Armed Forces Tribunal. He has more than 10 years of experience and he is also son of a फौजी और पढ़े लिखे हैं जैसे इनके पीछे रखी हुई है मोटी मोटी किताबों से दिख रहा है. And we keep on inviting him for sharing his technical wisdom and expertise and valuable suggestions on these value talks editions with us. So welcome to today's talk again, Advocate Varma.
It's always a pleasure, sir. Thank you so much.
So now without any further delay, मैं आपसे पहले एक टेक्निकल सवाल पूछता हूँ जो आजकल थोड़ा सा ज्यादा इम्पोर्टेंट हो गया है. What exactly is the difference between disability pension and impairment relief?
Okay, disability pension and impairment relief. Basically, in essence, both of them are a mode of financial compensation, which is awarded by the organization or let's say by the government to an individual, to an armed forces personnel who has sustained some form of let's say injury or any kind of disease or ailment having a causal connection with his or her military service, and that ailment or injury has resulted in some kind of a disablement or impairment, as the term nowadays is used, in the body of that individual. Both these compensations are given only after retirement. As far as difference is concerned, the difference is that disability pension is, as the term suggests, is a form of pension which comprises of a service element as well as a disability element. So the service pension that the individual would have or should have got will be the service element of the disability pension. The financial compensation towards the disability itself will be called the disability element. This is, as I already stated, is a form of pension. Even for those personnel who are otherwise not, let's say, eligible for service pension, they will also get it, and they will also, not only will they get the disability element, but they will also get a proportionate service element if they are found eligible for, or if they are granted disability pension by, let's say, the courts of law later on. However, in the case of impairment relief, it is not a pension. As per the definition given in the Entitlement Rules 2023, which are the latest on the subject, these shall cease upon these benefits, impairment relief, shall cease upon the demise of the titled personnel. And it has been very specifically clarified that this is not, I repeat, it is not a pension. And furthermore, this is my own understanding and my interpretation, although the situation is a little unclear as of now on this aspect. Earlier, people who were in receipt of disability pension, they were entitled to exemption on income tax on their entire pension, including the service element. It is understood and it is believed that by renaming the compensation from disability pension to impairment relief, there is a very high likelihood that the erstwhile income tax exemption will no longer be available or applicable to those personnel who are now in receipt of impairment relief after their retirement. Okay. There are a lot of similarities, but yes, there are also some differences.
Without really kind of getting into the nitty-gritties of disability pension, I would like to understand what are the criteria required, essential criteria, the minimum essential criteria required for grant of disability.
Sir, actually, disability pension and impairment relief, the criteria are identical actually. In fact, it's just that they're more or less identical. Disability को वैसे भी replace किया जा रहा है, disability pension को impairment relief से replace किया जा रहा है, तो rules more or less remain the same. The number one criteria is for both disability pension as well as impairment relief that your disability, for whatever disability that you're being assessed for, that disability should have a causal connection with military service. And it should also be opined to be either attributable to or aggravated by military service by the release medical board or invalidating medical board, as the case may be. However, I would like to add something on this after I've given the answer to the question. The second criteria is that the percentage of disablement as assessed by the competent medical board, which is the RMB or the IMB, must be 20% or more. In effect, it means that, let's say, for example, for illustration purposes, let's take one of the very commonly occurring diseases for military personnel, especially those who are retiring upon superannuation after completing their entire service at, let's say, in their late 40s or 50s. Officers will be mostly retiring in their 50s. That commonly occurring disease is hypertension, actually, high blood pressure. So that hypertension should either be aggravated or attributable. Mostly it is found to be aggravated. If at all it is considered as aggravated by the medical board, then the percentage for hypertension usually in the earlier regime, it was awarded as 30%. Now, in the latest set of rules, that is the GMO 2023, it has been deliberately and very wrongfully, I would say, in my personal opinion, the assessment has wrongly been reduced overnight, has been reduced to 5%. It used to be 30% earlier. In this particular case, the illustration that I'm giving, an individual who's retiring, let's say at 54 years of age, and is suffering from hypertension, has been found to be disabled to an extent of 30%, and the disability, that is primary hypertension, has been found to be opined to be aggravated by military service. So in this case, the individual or the officer would be entitled to grant of disability pension in the ordinary course. As I said earlier, that I wanted to add that even if for in practical application, even if the opinion of RMB is not in your favor, let's say the RMB has held or opined that yes, though the individual is suffering from hypertension and the percentage is also 30%, but it has found to be neither attributable nor aggravated by military service, जिसको हम लोग अपनी terminology में नाना भी कहते हैं short. So the disease is held to be nana, percentage is 30%. So in this case, though yes, the organization will deny the disability pension to you, but the individual has an option to represent, go through the channel, then come to AFT, and then after coming to AFT, there's a very high likelihood that that person will be given the benefit of doubt as per various precedents of the Honorable Supreme Court and other judgments of the AFT, and disability pension will be allowed or will be granted in his or her favor. Similarly, for wrongful assessment or incorrect assessment of percentage, again the same channel or same procedure can be followed, and if a person is aggrieved by, let's say, a wrong assessment or incorrect assessment of percentage of disablement, he or she can again approach the AFT and get relief from there. मैं इसको एक example से समझाना चाहूंगा. As per the earlier guide to medical officers of 2002 and which was amended in 2008, अगर कोई individual hearing loss के लिए LMC होता था, यानी लो मेडिकल कैटेगरी में होता था, तो एज पर दी गाइड टू मेडिकल ऑफिसर्स जो डिसेबिलिटी परसेंटेज है या डिसेबलमेंट परसेंटेज है वो 20% से कम नहीं हो सकती थी. ऑन अ बेयर रीडिंग ऑफ दैट चैप्टर व्हिच डील्स विद हियरिंग लॉस, the minimum percentage of assessment was 20. So anything below 20, by implication, anything below 20% is not fit for placing that individual in LMC. If the individual is being placed in LMC, then yes, mandatorily 20% उसका assessment होना ही चाहिए. However, due to a subsequent letter by the DGFMS, RMBs started assessing hearing loss routinely as less than 20% on various parameters, on various tests. Those assessments were challenged by many people. Many officers have challenged, many soldiers have challenged. Sailors, airmen have also challenged, and those cases have been bunched together. एक उनका bunch बन चुका है, वो इकट्ठा AFT is dealing with them, and they are pending before. By the way, they are pending before the larger bench of the Honorable Armed Forces Tribunal, and we expect an outcome in those bunch of cases very soon. In this example, though the policy held or mandated that 20% से कम नहीं होना चाहिए percentage of disablement, उसके बावजूद due to a policy letter, another which couldn't have superseded or overridden the GMO, incorrect or lower percentage was being awarded, and that was leading to denial of disability. So ऐसे केस में भी और किसी डिजीज में भी अगर किसी इंडिविजुअल के साथ ऐसा हुआ है, they can also challenge that incorrect or lower assessment of disablement.
वकील साहब, आपने जो बताया कि क्या होना चाहिए, कागज में क्या है, पॉलिसी क्या है, सब कुछ सही है. हालांकि आपसे मैंने जितनी बार भी बात करी, मुझे ऐसा लगता है कि फॉर वॉट एवर रीजंस द रूल्स आर नॉट फॉलोड. नाउ लेट्स से दे आर जस्ट नॉट फॉलोड. देन व्हाट आर द प्रोसीजरल स्टेप बाय स्टेप दो तीन चीजें जिससे कि मैं AFT तक पहुंच पाऊं. व्हाट आर दोस बेसिक प्रोसीजर्स फॉर अप्रोचिंग द आर्म्ड फोर्सेस ट्राइब्यूनल फॉर इफ आई हैव बीन रॉन्ग?
Definitely, sir. That's a very good question, in fact. So, AFT जाने से पहले कुछ procedures होते हैं जो which we also call pre-trial procedures that an individual must mandatorily undergo before one can file an AFT. एक बहुत ही बेसिक सिद्धांत या फंडामेंटल प्रिंसिपल है ऑफ लॉ व्हिच सेज दैट अप्रोचिंग द कोर्ट्स शुड ऑलवेज बी द लास्ट रिजॉर्ट, एंड बिफोर यू अप्रोच द ऑनरेबल कोर्ट्स ऑफ लॉ you should have exhausted all your other remedies which are otherwise available to you. In fact, that fundamental principle has been codified in the AFT Act, and there's a section which mandates that no OA or no application shall be entertained by the AFT unless all other alternate remedies, the technical term here is used, which is used as alternate remedies, have been exhausted by the applicant. As you asked, AFT जाने से पहले क्या करना है इन डिसेबिलिटी पेंशन केसेस और एनी पेंशनरी केसेस? सबसे पहले एक फर्स्ट अपील हमें फाइल करनी होती है विद द appellate committee on first appeals. This is basically a form of a representation is submitted to the appellate committee through the respective record offices. So for army officers, it will be officer record office in the AG's branch, and for soldiers, it will be respective regimental records. Routed से मेरा मतलब है कि वो भेजी जाएगी अपने record office को. Ultimately, it will land up with the appellate committee on first appeals, in short, which we refer to as ACFA, and in a fixed more or less मतलब sort of fixed time frame. 6 महीने कहा जाता है, बट कई बार उससे ज्यादा भी लग जाता है, कभी कम में भी हो जाता है. A response or a disposal is given to your representation. This first appeal essentially, if I may cover it in a very short manner, essentially should cover both the factual aspects of your case. It should be a little comprehensive, especially as to the facts. What were the attendant circumstances which led to the onset or detection of that disability in that individual? Uske working atmosphere kaisa tha? What were the nature of duties which could have contributed to the development of that disease in the body of that individual? And how, even after detection, that person or that individual continued to perform his duties, which could have led to further aggravation of that particular disease. इस बारे में बहुत comprehensively drafted होना चाहिए ये. It would be even better and it would be good if the legal aspects of that entire issue are also made a part of that first appeal, and then it is sent. Then it becomes a little compelling. The narrative should be compelling and should make it undeniable for the authority to not grant you relief. However, in most cases, it is seen that first appeal reject hoti hi hai and ultimately AFT jana padta. Now, the next step after first appeal is what we refer to as a second appeal. Second appeal for many benches of the Honorable Armed Forces Tribunal, it is optional. कुछ AFT के benches में insist किया जाता है कि first appeal और second appeal दोनों होनी चाहिए. उसके बाद ही आपका case को entertain किया जाएगा. उसके बिना वो admit नहीं किया जाता. But in some benches of the AFT, including the principal bench and the Bombay bench and a couple of other benches also, the second appeal is not insisted upon. It has been more or less made optional. And so, if an individual intends to file his or her case in the Honorable Principal Bench of the Armed Forces Tribunal, which is in New Delhi, then second appeal can be skipped or dispensed with. After this comes the stage of filing the original application. Original application, sir, is the nomenclature of the petition that we file in the AFT. Short में मुझे OA कहता है. In the OA, the aggrieved individual, जो कि हमारा सर्विस पर्सनल है, जो केस फाइल कर रहा है या कर रहे हैं, he or she would be referred to as the applicant, and the Ministry of Defense or the Union of India, which will be our opposite side, our opposition, they will be referred to as a respondent. This is broadly speaking, sir, this is the legal framework of seeking justice in your disability pension case.
अभी आज का सबसे कठिन सवाल जी, वो आपने OA जिसको बोलते हैं केस कर दिया, I'll sue you कर दिया, but what is the legal position on the disability pension for lifestyle disease such as hypertension, diabetes, मेरी तरह से जो मोटापा हो जाता है वो, और एट टाइम्स कोलेस्ट्रॉल के लिए भी देयर इज अ वेरी टेक्निकल टर्म डिस्लीपिडीमिया. वैसे आधे वकील डॉक्टर भी हो जाते हैं डिसेबिलिटी पेंशन से डील करते करते. सो ये वाली जो बीमारियां हैं जिसमें इनवेरिएबली ग्रांट ऑफ डिसेबिलिटी और इम्पेयरमेंट रिलीफ is denied. I mean, I'm yet to come across or meet anyone or who says ki they were granted the relief right when the pension started or when they separated from the services. Under the lifestyle disease impairment relief or disability pension is invariably denied. What is the legal position, or if I may say, the hope for these individuals?
I would answer this in a nutshell. I would say the legal position favors the aggrieved individual, irrespective of what the rule position may be. In a nutshell, this is what my answer will be. However, to expand upon it, it's a very good question. In fact, this is the essence of our talk or of this talk that we're having tonight. इसका ना एक बेसिक सिद्धांत है, एक बहुत ही फंडामेंटल प्रिंसिपल है इसमें, जो अंडरलाइंग प्रिंसिपल है. वो ये कहता है कि एक इंडिविजुअल when he or she enters the service is presumed to be in sound and good health, free from any disease or any ailment whatsoever. And when he or she enters the service, she is in shape 1 and undergoes very rigorous and thorough medical examinations and check. Now, during the course of service, for many of the personnel, not for all obviously, but many of us would end up being afflicted with some kind of or various kinds of ailments and diseases, including lifestyle disease. और कुछ लोगों को चोटें भी आएंगी, कुछ physical injuries भी होंगी. I will limit myself to ailments and especially lifestyle ailment for the purpose of this talk and for the question that you asked me. So it is given that during the course of service, as the person ages, as the workload also increases with more seniority, you will get more responsibilities and performance pressure. The workload, the quantum of the workload, quality of the workload will also proportionately increase as you progress in service. So it is a given that many of the officers and soldiers will, at the time of their exit or at the time of their separation from the service, will be found to be suffering from various types of disease. Lifestyle disease की बात करें तो सबसे ज्यादा commonly हम जो देखते हैं वो होता है hypertension. हम देखते हैं तो my experience suggests that diabetes mellitus, let's say type 2 diabetes is also one of the very, not very common but has become fairly common in the last 2 years. And कई cases में hypertension और diabetes दोनों हो रखी होती है individuals को. I happen to be having a good number of cases where people are suffering from either hypertension or diabetes or both, and it comprises a substantial chunk of my workload and my practice at this moment. People suffering from these two diseases. इसके अलावा obesity भी एक ailment है जो कई लोगों को हो रखा होता है, although not very common. There are some individuals. एंड देन कुछ लोगों को हाई कोलेस्ट्रॉल होता है जिसका टेक्निकल टर्म है डिस्लिपिडीमिया. कुछ मेडिकल बोर्ड उसको हाइपर डिस्लिपिडीमिया ही रेफर करते हैं. कुछ लोगों को इन सम केसेस, इन सम वेरी फ्यू एंड रेयर केसेस, अल्कोहल डिपेंडेंस सिंड्रोम भी होता है. अल्कोहल डिपेंडेंस सिंड्रोम की वजह से उनकी किडनी या लिवर में डैमेज भी होता है. दीज आर सम ऑफ द commonly occurring lifestyle diseases. So there are many more. Some types of heart diseases are also, they are not strictly speaking lifestyle disease, but they can be attributed to the lifestyle. So these diseases also, sometimes the medical boards would hold them as attributable, not attributable, but actually aggravated by military service, especially if that particular disease has been detected when that particular person was serving in a field area, CIOPS area, or in a high altitude area. In individuals के लिए तो जो release medical board है वो ही कह देगा कि yes भाई ये aggravated by military service. And for those personnel जिनकी detect हो गई ये वाली hypertension या diabetes, इस तरह की diseases, and afterwards they somehow, by mistake or by design, they end up being posted to a, let's say, a field area or a forward area or a high altitude area. ऐसा बहुत कम होता है लेकिन होता है. उनके केस में भी aggravation concede की जाएगी. For all others जिनका peace area में detect हुआ है या field anything other than a field or forward area or high altitude area detect हुआ है, तो उसमें तो medical board ही कह देता है कि भाई this is NA, that is neither attributable nor aggravated. इन दोनों ही केसेस में, और मैं दोनों केसेस इसलिए कह रहा हूँ कि हाइपरटेंशन और डायबिटीज जैसी बीमारी में जिसमें मेडिकल बोर्ड ने भी कंसीड किया होता है कि एग्रेवेटेड बाय सर्विस है, उसमें भी इन मेजॉरिटी ऑफ द केसेस द कॉम्पिटेंट अथॉरिटी in the AG's branch will say that we are not going to give you disability benefit. Your claim is rejected, it is disallowed. Nearly all the cases of lifestyle diseases, हमको ultimately AFT जाना ही पड़ता है या फर्स्ट अपील स्टेज में कई बार रिलीफ मिल जाता है. और इसमें कुछ जजमेंट्स हैं सुप्रीम कोर्ट की और उनको फॉलो करते हुए दे आर अम्पटीन नंबर ऑफ AFT जजमेंट्स. अम्पटीन मतलब कोई गिनती नहीं होगी शायद, इतनी जजमेंट्स हैं जो ये होल्ड करती हैं कि सिंस एन इंडिविजुअल इज प्रिज्यूम्ड टू बी फिट एट द टाइम ऑफ एंटरिंग सर्विस एंड ही और शी इज इन शेप 1, देयरफॉर एट द टाइम ऑफ एग्जिट फ्रॉम द सर्विस इफ एनी individual is found to be suffering from any disease whatsoever, it will be presumed that it has occurred due to the fact of his military service. There is a judgment of the landmark judgment in this regard. दो तीन है सर. सबसे पहले धर्मवीर सिंह वर्सेस यूनियन ऑफ इंडिया, ये 2012-13 की जजमेंट है, 2013 की इनफैक्ट. और फिर उसको फॉलो करते हुए, उसको एक्सपाउंड करते हुए एक जजमेंट है यूनियन ऑफ इंडिया वर्सेस राजवीर सिंह एंड ऑल्सो सुखविंदर सिंह, जो इन्हीं प्रिंसिपल्स को और फर्दर एक्सपैंड करती हैं. फिर एक 1993 की सुप्रीम कोर्ट की जजमेंट है व्हिच इज टाइटल्ड एज एक्स सैपर मोहिंदर सिंह वर्सेस यूनियन ऑफ इंडिया एंड अदर्स. ये 93 में फैसला आया था. इसमें ये होल्ड किया गया था कि अगर रिलीज मेडिकल बोर्ड which is a duly constituted expert body has given a particular opinion which is in favor of the individual, and thereafter an administrative body or a higher formation cannot overrule the opinion of that duly constituted medical board. So in cases में जिसमें opinion होता है medical board का कि hypertension या diabetes या any such similar disease is actually aggravated by service due to whatever reason, mostly it is because it was detected in a field area or high altitude area, उसके बावजूद AG's branch competent authorities को मना कर देते हैं देने से पेंशन. इन केसेस में हम ये जजमेंट यूज करते हैं और it actually comes to our relief, it comes to our aid, and AFTs routinely give orders in favor of such personnel. In fact, even I would go on to say that in exceptional cases, in very few exceptional cases, one could also argue that obesity भी मेरी military service की वजह से ही हुई है. इसको मैं कैसे, I would explain that with an example, with a hypothetical example, and it is a very uncommon argument. It is kind of like only in extreme cases we can argue this. Recently, I was speaking to an officer and we were discussing his case. During a parachute jump, the officer sustained some injuries in his back. He was placed in LMC, of course, for that. The officer was placed in LMC for that injury. Thereafter, due to that injury and due to the severe restrictions on his movement and ability to exercise and move around, soon thereafter, in the span of next 3 to 4 years or 5 years, that officer has developed obesity and other related ailments like hypertension, etc. In that case, one could potentially argue that this obesity is also because of another injury or another ailment, another problem, which was caused due to a bona fide during the course of bona fide military duties. I would also say that whatever lifestyle a service member enjoys goes on a day-to-day basis. To a large extent, it is dictated or decided by the norms and rules and regulations of the service. So ये lifestyle भी मुझे फौज ने ही दिया है जो मेरा lifestyle. So if there is any lifestyle disease, has to be aggravated by or attributable to military service. And AFTs routinely come to the aid of such people.
Now, when you say that AFT has routinely given judgments which are in favor of individuals who have approached AFT, and I'm specifically talking about lifestyle disease, not to mention other injuries or the other disabilities which have happened over the course of a difficult service in the uniform. इसके बावजूद, and it has again been, अमिताभ बच्चन की मूवी है ना, सरकार, उसके लिए the other guy says उन्हें सरकार है. So that means they are kind of above law. In spite of getting judgments, it has been seen that they are not complied with. I think you are also instrumental in one of those cases where you have taken it upon, you have moved High Court, or you are part of that team which moved High Court, wherein AFT should be given more powers to carry out a contempt. So what do I do in case I have obtained relief for a lifestyle related disease, and now in spite of having obtained relief from AFT, I'm not getting the money or the compensation which is due to?
So actually that case that you're referring to is a AFT decision, a larger bench of the AFT, which has, in essence, it has held that in cases where it appears that respondents are deliberately avoiding implementation of the judgments or orders of the AFT, then the AFT will be well within its powers to invoke civil contempt, powers of civil contempt against these people who are causing the hindrance or avoid are deliberately causing non-implementation. So this case actually, this is title of that case is Lieutenant Mukul Dev versus Union of India. It was a contempt application. Actually, there were many cases, 4-5 case, 6 case bunch ho gaye the saath. And I played a very small, very nearly insignificant role in the overall process. However, that judgment has come. It is, I think it came last couple of months ago in July, end of July, I believe. So yes, there have been some systemic issues and in the implementation of AFT orders and judgments. And it was being said once upon a time that government is not serious, or the Ministry of Defense is just not serious about implementing orders of the AFT. And actually, this is my personal submission or personal opinion. There have been some cases where there has been so much delay. Such a casual approach is taken by the organization. Even after rendering of the judgment by the Honorable Tribunal, there is hardly any effort to get them implemented, and the individual has to run from pillar to post even after getting the order in his. In this regard, मैं छोटे से कुछ suggestions देना चाहूँगा to any person who is currently in AFT or contemplating going to AFT, that after your battle is not over once you get the judgment. There is something, there are certain things, there are certain steps that need to be taken even after obtaining a favorable judgment. Number one, once you have obtained a judgment, one must apply and get a copy or certified copy of the AFT order or judgment. Thereafter, that certified copy must be sent along with the covering letter by post to the respondents, especially to the AG's branch, telling that I have obtained this and so kind of judgment in my favor. Is dated so and so. A copy of the same is attached herewith. And usually in every judgment there is a time frame given for its implementation. तो आमतौर पे 3 या 4 महीने दिए जाते हैं जजमेंट में. ये हमारा जजमेंट है और इस जजमेंट को आपको अगले 4 महीने के अंदर इम्प्लीमेंट करना है. So you must especially make that assertion in your covering letter that the Honorable AFT has given you so and so period of time to implement the order. Therefore, you are requested to take cognizance of this judgment and give effect to the instructions or directions of the Honorable Tribunal within the time frame as fixed therein. उसके बाद हो सकता है आपको 1-2 बार periodic reminders भी भेजने पड़े, भेजने चाहिए. Thereafter, if the judgment of AFT is not being challenged in the High Court or Honorable Supreme Court, as the case may be, and if at all, even if it is challenged, if there is no stay on operation of the judgment, where High Court ने Supreme Court ने stay नहीं लगाया है उस पे, तो और उसके बावजूद respondents को implement नहीं कर रहे हैं, वो 4 महीने का time भी निकल गया, implement नहीं कर रहे हैं, then individual should again approach the AFT by filing an application, which we call as the execution application, or in some other benches it is referred to as execution petition also. We need to mention, or we need to make an assertion, averment in that application that this was the judgment of the Honorable Tribunal which was in my favor. I so and so letter I had communicated the same to the respondents. Despite passage of so many months, there has been no steps have been taken by the other side to get the order implemented. Therefore, I am praying to this Honorable Court to get its order implemented, to give directions to the respondents to implement the judgment or the order. And जैसा कि मैंने कहा इससे पहले कि अगर deliberately ये प्रतीत होता है, if it seems that there is deliberate non-implementation of the order by any concerned official, be it Ministry of Defense or any arm or organ of the Ministry of Defense or the services headquarters, the AFT can always invoke their powers of contempt and summon that person that person in their personal capacity to appear before the tribunal, and as per the contempt court law, there are legal principles governing the contempt of court. उसके अनुसार जो भी punishments levy की जा सकती हैं, impose की जा सकती हैं, those can be levied on that individual. So now we hope, by we I mean the practitioners of Armed Forces Tribunal, we are hoping that things will take a very positive turn. And जो पहले एक साल लग जाता था implementation में, या maybe more than that, now things will move at a smoother and faster.
So, just to sum up our today's discussion, one, impairment relief या disability pension जो भी है वो technical नाम बदल दिया है, but other than that, the conditions to grant the financial compensation, whether as disability pension or impairment relief, remain more or less the same. In case of lifestyle diseases, it becomes even more pertinent for individuals to approach AFT by following the steps which you had given: first appeal, second appeal, and then, or in case of principal bench, maybe even foregoing the second appeal. And there have been cases in the past where AFT has granted relief to individuals even when they have been denied due to the lifestyle disease. And now, due to some recent changes, as you had said, due to some recent judgment by a larger bench of the Armed Forces Tribunal, Armed Forces Tribunal can also invoke civil contempt in case their orders are not implemented with due speed and efficiency. So as to say, this is what you have told. Anything you would like to add before I thank you for your time for today and move to the audience?
Of course, sir. It's my pleasure, sir. It's always been a pleasure.
All right. So thank you so much, Harsh, for your time. So you're listening to Advocate Harshvardhan. He practices with the Armed Forces Tribunal Principal Bench, also with the Armed Forces Tribunal Lucknow Bench. Thank you so much.